Into his command. It is then that we shall rise, we shall pursue, we shall overtake, and we shall conquer all of our adversaries, and we shall shout at last, the Lone Star forever, the Lone Star forever. Oh, long may it flow o'er land and o'er sea. This dreaded Lord never uphold it forever. And shout for the Lone Star. Battle! Oh, hell, hear him, mama. Bless my mama, oh, hell, be him, mama.
Hello and welcome to another edition of 2A radio broadcast. Today we will be talking with you concerning the Constitution, the laws of the land of the Republic of Liberia. Tonight we have with us some wonderful personalities, and we have Councillor Arthur T. Johnson, and we have Attorney James Jensen. So you are welcome to 2A Radio.
Thank you so much. I'm glad to be here today in a special way.
We want to give the opportunity to our special guest tonight, Councillor Johnson. 2A Radio boss is on, so he's not a guest. So, Councillor Johnson, you are welcome, and we want you to introduce yourself, and then we'll go back to Mr. Jensen.
Okay. Thank you That's the patience of
Patience.
it. I'm Councillor Johnson, a Liberian lawyer. I'm a member of the Honorable the Supreme Court of Liberia Bar. I practice before the Supreme Court of the Republic of Liberia, and I'm a criminal justice practitioner also, a professor of criminal justice and dean of the Criminal Justice College of Liberia, AMISA University, the Wilfred Clark College of Criminal Justice and Law Enforcement. It's a pleasure to be here.
Thank you, thank you, thank you. Anthony Jensen, introduce yourself, please. We can't hear you. We're giving Councillor Jensen some time to adjust his mic. So bear with us. Can you hear me, Jensen?
Yes, I think I'm hearing you right now. Am I okay?
Yes, you're okay.
Okay, as I was saying, I'm Anthony James and Jensen. Although when I say Anthony, is referencing a mission to practice law in the Republic of Liberia. Currently, I'm a resident of the United States. I lived in Pennsylvania, the United States of America. And I'm a graduate from the Pennsylvania State University with a master's degree in law. And today I'm happy to be here. I'm also happy that my friend and brother, Councillor Arthur T. Johnson, is with us today. Thank you so much. I'm glad to be here.
Thank you, thank you. Today we will be discussing a very special case. I think we saw that on the flyer, and I just want to bring it briefly so we can see what we're talking about. I won't be able to bring it on screen, but we're talking about the Constitution, the laws, and youth. And we are very specific tonight, talking about the laws of Liberia. And in today's discussion, we are going to be talking about Liberia's immigration and naturalization law on citizenship, or critical analysis of the Supreme Court ruling in the case of Abintish Jallo versus GOL. So tonight, what you can do for us is share the video and be part of this discussion. We have for comments and questions, we have the number on the screen, and you can call us to make your contribution, or you can make some comments on the comment section under the broadcast. The Supreme Court of Liberia recently ruled in a case, Alvin T. Jallo versus GOL. In the case, Jallo petitioned the Supreme Court complaining that the government of Liberia denied him passport after application to have allowed him travel to Liberia. In response, the government of Liberia said Jallo was denied passport because Jallo has taken on United States citizenship. Further, the GOL contested that the Supreme Court could have denied Jallo petition because he never had rights or standing to sue the government of Liberia. The court's decision, the Supreme Court of Liberia decided that Jallo case was as follows. On the issue whether Jallo had right to petition the court, the court said yes, Jallo being affected, he had the right to petition the court. The second issue the court decided was, before the government considers revoking a citizenship of Liberian, there must be a judicial proceeding, like a hearing at the Liberian embassy in a foreign country where the person naturalized. Now, these are the facts of the Supreme Court. And I hope we can address this issue here tonight, since we have Councillor Johnson and we have Anthony Jensen. So we're going to be limiting ourselves to just a maximum of 2 minutes or 1 minute each person to just give your opinion, as it concerns this case tonight. So I want to start with our guest, because he's the guest of honor tonight. And We need to give honor to whom honor is due. So we're going to start with Councillor Johnson. You are welcome. Your opening statement tonight.
Okay, thank you. My opening statement is that the Honorable the Supreme Court's ruling in this particular Tish Jallo's case, is not a pass. It's not a pass or a card for anyone to believe that indeed the Supreme Court had approved dual citizenship in Liberia. That's not true. The Supreme Court has specific issues before it that were raised, and it made the decision on the basis of those issues. And those issues are: one, whether Jallo had standing, even though the Liberian government at the time automatically revoked his citizenship. The Supreme Court said yes, he had standing, because standing is whenever a decision is taken by an agency or institution, whether your interests have been affected and whether you have remedy at law. On the basis of that, the Supreme Court said yes, he has standing. Two, the issue before the Supreme Court was whether or not Jallo was given due process of law consistent with Article 20 of the Constitution of Liberia that falls under Chapter 3. The Supreme Court said no, due process was denied. He was not accorded due process. Under our laws, if a person is accused of violating the laws, under Article 21A of the Constitution of Liberia, it provides that there must be a hearing consistent with due process, as was enshrined in the landmark case that unfolded in the Liberian jurisprudence they call Wallow versus Wallow. That was the landmark case that said due process must be a law that is fundamental, is the law of the land. So it is not an interpretation that Liberia had approved dual citizenship. That is not the opinion of the Supreme Court. So the Justice Minister was correct. In his letter interpreting the Supreme Court's opinion, that particular statement was correct, telling the Ministry of Foreign Affairs that whenever the issue of violation of the election, let's say the violation of the immigration law as it relates to dual citizenship, you must accord the person due process, not to follow Section 22 of the 22.2 of the naturalization law that says that it is an automatic revocation of citizenship. Thank you.
Thank you, Councillor. Now we want to come to Attorney Jensen.
Well, Patient, thank you so much. And I want to say thanks to Arthur for his position taken on this matter. Well, as you stated the fact rightly, I'm not going to repeat that, Patient. This is a case involving Arvin Tish Jallo, who happens to be a U.S. citizen, a naturalized citizen, at the same time applied to the Embassy of Liberia in the United States for a passport to allow him travel to Liberia. Now, the issue that was raised by the Honorable Supreme Court, to which he addressed, as Arthur rightly said, which I agree, was the issue of standing, whether Jallo had the right on the Liberian law to petition the court, to seek favorable response relative to his petition filed, his application for a passport. I'd agree fully with the Supreme Court on that decision that Jallo indeed has standing because he was affected by the decision taken. On the issue as to whether or not the Supreme Court has recognized naturalized Liberian or whatever the government of Liberia has recognized dual citizenship. It's a very critical issue, and I want to take a position on that. And I feel by application of Jallo to seek his right under the laws of Liberia, the Immigration and Naturalization Law of Liberia, to say that he is a citizen of Liberia when he's been naturalized, and for the court to grant him that right to the point where the court said that due process was not accorded him. So my position is that the fact that the court has taken that decision that the government of Liberia was wrong by denying Jallo his passport simply because they should revoke his citizenship because he needed due process before doing that. So just to me, by implication, that Jallo is still a Liberian citizen and a U.S. citizen. That being said, that being said, bring into question dual citizenship. Now, when we go to the Constitution of Liberia, Article 27 and 28, it is clear that all Liberians have right and they should not be denied the right of citizenship and naturalization. That's the Constitution of Liberia. So
Okay.
Jallo's decision to get naturalized to America or as an American citizen meets Article 28 of the Liberian Constitution.
Okay. Thank
That
you.
right is given to him.
Thank
He
you.
has a position that dual citizenship by implication is being recognized by this ruling of the Honorable Supreme Court of Liberia.
Thank you, Anthony Jensen. Now, both of you briefly went into my first question here tonight, but nevertheless, I'm still going to ask that question. How will you describe the Supreme Court ruling? How will you describe it? I want to start with Councillor Johnson.
Well, you see, thank you. You see, the Supreme Court. One of the ways, if you practice before the Supreme Court, you will understand that the Supreme Court does not engage in. There's something in law we call the doctrine of advisory opinion. The Supreme Court does not about giving opinions or giving advices on issues that have not been before it that are considered to be justiciable. Justiciable, talking about legally contended issues that have questions of law for which the court of law must make an interpretation. Now, whenever you file a petition before the Supreme Court, the Supreme Court goes specifically to what you are asking in your contention. The Supreme Court will not raise new issues. Jallo filed a petition before the Supreme Court. He raised two major issues. One, he said he has the legal capacity to question the action of the government of Liberia to automatically revoke his citizenship and deny him of his citizenship without a hearing. The fact that he was denied a hearing, which is issue number two, Jallo was asking the Supreme Court to decide on those two issues. The Supreme Court will not go ahead to raise a third issue about whether dual citizenship is legal under Liberian law. The Supreme Court will not do that because it is not the issue before the court. That is how the Supreme Court operates. And that is why you will always see that the Supreme Court deals with issues that are before it. And again, sometimes the Supreme Court decides if you can raise more than three issues. For example, the Supreme Court decides which issue that it must pass upon. That is the prerogative of the Supreme Court. But let me come here quickly. When the Chief Justice was delivering the opinion of the Supreme Court, there is something in judicial ruling and opinion we call the doctrine of, I will explain that, they call it the doctrine of ratio decidendi. It means they call it the rationale behind the decision. Whenever a court is making a ruling, the court must give reasons why it is making such a ruling, why it is giving such opinion, why is it holding the way it's holding. That is the rationale behind the decision. When the Supreme Court was giving this opinion, they gave an analogy. If you go to the ruling of the Supreme Court, you check on page 7 and page 8. The Supreme Court went on the doctrine of stare decisis, meaning the doctrine of precedence. That is to say, if the court is deciding an issue, and indeed it is looking for a precedent, whether there is a case that was decided before that in that particular jurisdiction, like in Liberia, the decision that was taken in that particular case would be the decision that will be considered as the ruling or the law or the controlling law to decide a new case. So if you don't have a case of that nature, you go to other jurisdictions. That is what the Supreme Court did. So they went to the United States of America to find out whether there were similar cases of Jallo scenario that came before the Supreme Court of Liberia. And the Chief Justice recognized two cases. One of those cases was the issue that came before the Honorable Supreme Court in 1967 in the United States of America, Afroyim challenged the constitutionality of the immigration law that has to do with Section 401 and Section 408. That is the knowledge of the Supreme Court now. And in that case, it was the same issue raised by, almost the same issue raised by Tish. Afroyim questioned the Supreme Court, the action of the government of the United States for automatically revoking his citizenship, American citizenship, because he participated in an elections in Israel.
Okay, Councillor, before you continue, we'll hold you there, and I want for Jensen to respond to that question before you can come back and continue. Jensen, remember you have 2 minutes each.
Okay. The question you asked is that whether
How
or not,
how will you describe the Supreme Court ruling?
the Supreme Court ruling, the simple definition I will have that anyone listening to us would agree is that the Supreme Court of Liberia decided on whether Jallo has standing to go before the Honorable Supreme Court. In my view, I maintain Jallo indeed has standing. I agree with the Supreme Court on that count, that the Supreme Court has standing, Jallo has standing to go before the Honorable Supreme Court for his rights to be given or to be interpreted. On the issue as Arthur Johnson is presenting, that the Supreme Court only had 2 issues. The Supreme Court of Liberia has a constitutional authority to interpret the Constitution and the laws of the Republic of Liberia. Hence, beyond the 2 issues that was raised, the Supreme Court, the Constitution, Article 27 of the Liberian Constitution and Article 28 of the Liberian Constitution clearly deal with the issue of citizenship and naturalization. There was nothing to stop the Supreme Court to have interpreted what it meant when the Constitution said every Liberian had a right to naturalize or to become a citizen of whatever country he or she decides. So Jallo, as a citizen of Liberia, decided to become a naturalized citizen of the United States. Nobody forced him. Jallo has an alienable right as a citizen, as a born citizen of Liberia, but upon his own accord. Now, the case started by the Afroyim case started by Arthur Johnson. There's a word in there that the Supreme Court of the United States said that Afroyim, because he did not assent, the word assent means he did not agree. It was in his will to say that, look, I don't want to be a citizen of the United States. So until then, he asked the court to go back on their own ruling to see whether Afroyim could get his right on U.S. laws. Now, if I may even go detail into that citation, 1967, there are a series of cases that have come beyond that case, that law that was cited by the Honorable Supreme Court, like the immigration laws of the United States. It's revised almost every administration. Citizenship is one of the crucial issues that is not taken lightly by the United States. So Jallo stands on the position of being a citizen of Liberia and a citizen of the United States based on this ruling until there is a judicial proceeding in line with Article 20 as the Supreme Court provided on due process. So until due process is accorded Jallo, which I agree, Jallo remains a dual citizen. That means he's a citizen of Liberia and a citizen of the United States. What is the position there? By implication, I would say the Supreme Court created more doubt, not on Jallo, but on Liberians who have naturalized themselves to other countries around the world. Nothing stopped the Supreme Court, but the Supreme Court gave interpretation of the Constitution and the laws of the United States by making it very clear, would have provided clarity in the minds of those Liberians who have naturalized themselves. But as I speak to you, there are Liberians who are now believing that they can hold Liberian passport and U.S. passports. Is that the case? In my view, no. Any Liberian who takes such a chance, when you go to the port of entry, you can either be jailed because of that. So my position is the Supreme Court indeed created more doubt in the minds of Liberians than providing clarity. It wasn't just a single most issue that went before them. The Supreme Court is under constitutional duty to interpret what the law says.
Okay, Anthony.
The Constitution and the laws of Liberia.
All right, we want for Councillor Johnson to or respond to that before we.
Thank you. Jackson, let me just correct that quickly. The Supreme Court does not interpret a provision of a statute when that issue is not squarely raised before the court. The court will never do that. Whenever the court does that, it is engaged in an adversarial opinion function. And under the doctrine of adversarial opinion, the court will not go to look for issues or to raise issues that have not been raised before it. They must be justiciable, meaning there must be the contention before the court.
If I may just ask you before you proceed, moderator, please permit me.
Yeah, go ahead.
From what you are saying, Arthur Johnson, are you telling me in your mind it is clear that Jallo is an American or Liberian, or Jallo is in a position of being a dual citizen? Is it clear in your mind that the Supreme Court ruling is not an issue that created doubt in the mind of Jallo?
You see, we as the lawyers, when we are dealing with this issue, we must deal with it from the legal perspective, not from an approach where maybe we'll be thinking what we expect and what we want.
Right.
The rationale behind the decision of the Supreme Court is this. The Supreme Court, because Jallo raised the contention that sections 22.1 that defines, first of all, that particular section defines the actions that you can carry out to be in violation of the immigration law.
For me,
And section 22.2 that talks about automatic revocation. The Supreme Court said for them, in their view, that word "so," it means that automatic revocation. So you must have a proceeding to be carried out. You made reference to Afrayon, but there is another reference that the Supreme Court made with another American case that has to do with Vance and Terranzas. Terranza went and pledged allegiance in Mexico. The Supreme Court analysis in that. In fact, the United States Supreme Court said, even though it met his consent, his action met his consent, but there must be a hearing for which the standard of proof must be what we call the preponderance of the evidence, not reasonable doubt. It must not be a criminal proceeding. It must be a proceeding that is governed by civil procedure. And then it must be on the basis of the preponderance of the evidence. What is the meaning of preponderance of the evidence? For the listeners, preponderance of the evidence has to do with the number of witnesses that you produce to substantiate your claim. And on the basis of that, the one that have the weight and the credibility in their testimony, the jury will decide. That is what the Supreme Court said. And in fact, in the United States Supreme Court opinion, it did not say that it recognizes or approves dual citizenship in America. No, the Supreme Court of the United States, according to the opinion, because if you read the Immigration Act of the United States, it was copied verbatim by the government of Liberia or the people of Liberia, what we call the immigration law. The Supreme Court even cited that. So what the Supreme Court is saying, government of Liberia, we recognize that section 22.1 is not in violation of the Constitution of Liberia. But section 22.2 that says automatic revocation is in violation because it fundamentally undermines due process, Article 20 of the Constitution under Chapter 3. So let the president have a hearing. That's all. Now, the reason the Supreme Court did not say in its opinion that the government of Liberia go ahead and prosecute or have a hearing against Teach is that the Supreme Court will be taking the role or assuming the role of the executive to tell the executive what to do. The court will not do that. That is why the court rule is a law. The law is, under Article 21, whoever is accused of violation, whoever violates the law, the person must have their day in court. And the fact that this law provides that automatic revocation without a hearing, obviously is a violation of the Constitution under Article 20. That is why when the Minister of Justice wrote that letter, the Minister of Justice was not in contradiction with the opinion of the Supreme Court. The Minister of Justice was only informing the Foreign Ministry that even though if you find out the person is a citizen of Liberia and they are citizens of another country and they come to you for renewal of their passport, you cannot automatically deny them until you can have a hearing consistent with due process. That is not a pass I want to admonish all Liberians. It's not a pass. I'm coming, Jensen. It is not a pass card for any Liberian to believe or feel that indeed Liberia, the Supreme Court opinion, has indeed approved dual citizenship. No. Read the opinion of the court. Look at the rationale of the decision of the court, and you will see what really is saying. It is saying that when, for example, let me give you a quick analogy before I stop. Jensen, under our laws and the United States law, when a man is caught killing a human being, and that when he jukes somebody with a knife in front of so many persons, and that person dies, he is not a murderer until he is convicted in a court of competent jurisdiction by a peer. That is exactly what the Supreme Court is saying. That is why the Supreme Court cited Wallow versus Wallow. Wallow is the landmark case that has to do with due process under judicial review in our country. Thank you, Jensen.
Okay, Arthur Johnson. Fisher, we're not hearing you.
Thank you. I said my next question is exactly what we are discussing now. Does the ruling, permits naturalized Liberian to hold 2 passports? Jesse, you want to start?
Yeah.
For my own answer,
let Jensen respond to that.
Okay, but before I go to that question, let me say this, and I'm going to be very clear on that. Article 28 of the Liberian Constitution, the last paragraph, it says, Article 28, the last paragraph says, no person shall be denied the right to change citizenship or naturalization. I emphasize, Article 28, the last paragraph, provides that the Constitution, the framers of the Constitution of Liberia, mandated that no person, neither even the Supreme Court of Liberia, has no right to deny any Liberian naturalization or citizenship. That is a caveat. What else do we need for someone who has decided upon his own will to become a citizen of the United States? Christina Todd and all of those who acted at the time, in my view, they were right. Because Jallo decided upon his own will to become citizen as provided for under the Liberian Constitution. And I maintain there's nothing that stopped the Supreme Court of Liberia, the current bench, to have referenced this provision of the Constitution. This is an automatic decision. So the word automatic was just chosen by the framers of the statute in 1973 to allow the statute 22.2 to exist. That when you take on another citizenship, it becomes automatic as provided for under Article 28 of the Liberian Constitution. The Constitution said no one, neither Corpus or Chief Justice Corpus nor his bench has any right to deny anybody. So the man took upon himself to become a citizen of the United States. It is automatic. So the government of Liberia to deny him passport, they were right in my view. Now, let me be clear on this. The Supreme Court decision is final. There's no argument about that. They are the final arbiter of justice. I want to be very clear on that. I'm not disagreeing with them in principle to say the law cannot exist. That's not my argument. My argument as a lawyer who also have an obligation to say what the law is, but not the final saying, means then that the Supreme Court, in my opinion, did not interpret Article 28 that would have given the basis for all Liberians, not just Jallo, that those who have naturalized themselves, they did it on their own accord. So therefore, they have automatically forfeited their Liberian citizenship. That's what the Constitution says. No one should deny any Liberian the right to become a citizen or naturalized person. Article 28 says that. So what other procedural or judicial proceeding do you need when the Constitution has spoken? After you want to read, go to Article 28 of the Constitution, it says that clearly, the last paragraph. It says no one should deny a Liberian a right to be a citizen or naturalized person of another country. So what other judicial proceeding do you need for Jallo?
Okay, Counselor, you want to respond to that?
Jensen, there is something we call the doctrine of harmonious construction when it comes to the interpretation of the law. When we're interpreting the law,
you want to bring a judicial jargon here. We want people to understand what we're saying.
No, I'm speaking. No, I don't just talk.
Go ahead. Go ahead.
No, not just talk. Under the doctrine of a harmonious construction, those are the principles. Those are the concepts that Supreme Courts or other courts can use all over the world to interpret statutes. It says that whenever the court intends, or whoever who is a legal practitioner intends to interpret the law, you must interpret the law holistically. Look at it holistically.
I agree with 100%. I agree with you on that.
Good. What you just did, you just single-handedly took a particular sentence within a whole clause of the Constitution, and you left something else. They said no one shall be denied citizenship without the law. You left that aspect off.
Arthur, listen to me.
Before
you proceed,
let me read it. Mm-hmm. You did not read all. They said no citizen of the Republic, because exception to the laws proves the case. It said no citizen of the Republic of Liberia shall be deprived of citizenship or nationality except as provided by law.
Right.
Mm-hmm. So what the Constitution is saying? A Liberian citizen can be deprived of citizenship consistent with law.
Arthur, the Constitution.
I don't want to make that clear.
Yeah, but let's be clear. Yeah, go ahead.
let me make that clear again. Mm-hmm. You also said the Supreme Court should have dealt with the issue of nationality, dual citizenship. Jensen, comrade, I keep telling you, the court cannot engage in fishing expedition. That's one.
Let me be clear on that, Arthur. Before you proceed, let me say this. The
court cannot get involved in adversary opinion.
Arthur, that's not what I'm saying either. And I want our listeners to be very clear on this. Jallo took his case before the Honorable Supreme Court. Jallo, as a U.S. citizen, naturalized citizen, is a Liberian citizen. He goes for a passport to allow him travel outside of the U.S. Now, Jallo's position, the case before the Honorable Supreme Court, or that went before the Honorable Supreme Court, was Jallo in a position of what? Of a dual citizen. Even though Jallo wanted to say, I have my right to go before the court and to seek my right. That I have no argument. Jallo, at any point in time, the fact that he was denied, he has a right to go before the court for an answer to his problem. But Jallo, as a dual citizen, went before the Honorable Supreme Court. Now, the court said what? Article 22.2 says, before your citizenship is revoked, you must be accorded a judicial proceeding before an embassy, or somewhere, some court proceeding, some administrative proceeding will go on before the government of the Liberia say you are denied. But I'm telling you what the Constitution says here. Now you said the Constitution I'm reading here, I don't know what law you're reading that you said, except what? I'm reading what it says, and no person shall be denied the right to change citizenship or nationality. That's what it says right here before me.
Provided by law, except as provided by law. The same sentence. Okay. And no person shall be denied and the right to change citizenship or nationality. You can't deny the person if the person wants to change. You can't deny the person if the person wants to be an American citizen.
That's definitely so. So I'm just making reference to you, Arthur. I'm making reference to you that the lawmakers in 1973, the lawmakers in 1973 acted on the basis of this decision, that automatic decision for a Liberian to make a decision to be a Liberian or an American. Now, let me put it this way. Now, the Supreme Court has ruled, right? We all respect the Supreme Court ruling. Does that change anything? In my view,
of course.
No, it doesn't. In terms of the issue, Jallo remains as a Liberian and American until a due process is accorded him. So even if the due process is accorded him, can they deny Jallo his citizenship?
Counsel, let me tell you, maybe you live in this step. You are stepping this thing. Maybe you leaving something back. But let me tell you this: why you trying to leave behind? The Supreme Court is just saying to you, it's just like in the case of habeas corpus. Police arrested somebody for killing, and they kept the man for more than 3 days, more than 48 hours. Then the man filed a petition before the court of habeas corpus for his release, because the Constitution says you cannot keep a person beyond 48 hours without formally charging the man. Should the court say, no, you already been charged? They say you killed somebody, so you're not supposed to come here? No. The law is, there are procedures. The law is you must be accorded due process. I keep telling you, the Supreme Court ruled in a manner that they were anticipating that it is possible the Ministry of Justice will proceed to prosecute Jallow or to proceed to take Jallow to court to revoke his citizenship by a proceeding that will be governed either by the preponderance of the evidence.
There's no question about that. There's no question.
Yeah, I come in. Give me chance, Jensen. Give me chance. Let me learn. I practice before the court, so I know how sometimes they can do their ruling. So I understand sometimes with the ruling, setting with the rule. The next thing is the court anticipated that. And so because of that, they cannot say, Justice Ministry, before you take the thing, okay, go now and proceed. The court had already spoken in an implied manner like, look, it is your authority to revoke this man's blessings. But
I like the word implied.
Yeah, it is implied. It is your authority, but you must do the right thing. That is all the Supreme Court is saying. The Supreme Court is just saying, Justice Ministry or government of Liberia, you did not follow the procedure. The law that you rely on is draconian. That particular law is archaic. That particular law was repealed by implication when January the 6th, 1986, the Constitution came into existence. That is what the Supreme Court said. So the Supreme Court is saying, it is not telling you that Jallow is not in violation of the law. It is saying, copying from the opinion of the Supreme Court of the United States, that there must be a hearing consistent with due process to show that indeed Jallow really intentionally did what he did, and in order to deny him of his rights, follow what we called Article 20, which says there must be a hearing, there must be a jury. That's what the Supreme Court is saying. Let the jury decide that Jallow is in violation, because that is what our law is, no matter what the evidence are. The same thing is in the practice, Jensen. You've been practicing.
I understand all of what you said, which is not an argument for me, right? But the argument
it is not, Jensen.
It is not an argument. It's not an argument.
If it is not an argument, you cannot tell the court that the court should have engaged in advisory opinion.
No. What I'm saying to you.
That's what you said.
But listen to me. Yes, I'm a team my position, but give me chance. Let me state my position clearly.
No.
Give me chance. Let me state my position clearly.
I already got your opinion. Let me just learn.
No.
You didn't give me chance to learn.
Okay, go ahead. Go ahead.
You got to give me chance. Let me learn.
Okay, go ahead.
What I'm trying to tell you, the courts are regulated by 5 major doctrines. You know that. You have what we call standing. When case goes before the court must decide whether you have legal capacity. Because the first reason why the court decides legal capacity is that the court does not want to get involved.
Can we look at the issue of all of you political and the legal doctrines? To me, is something that we have an issue before us.
But that was one of the issues.
Yeah, but that's true, and I have been there. And I have no disagreement with that. I told you initially I agree with the Supreme Court on that matter, right? But what I'm telling you here is this, and in the words of Justice Scalia, one of the justices of the Honorable Supreme Court, the United States, may his soul rest in peace, he said this Supreme Courts in countries should always interpret laws to clear the doubt on the minds of the ordinary people who the law is supposed to affect. Now, as far as I'm concerned, the Supreme Court has said that Article 22.2 of the Immigration and Naturalization Law does not exist. And as such, hearing consistent with Article 20A must be applied. I have no argument as far as due process is concerned. But my concern, as I raised, is that Jallow, until a hearing consistent with the Article 20, remains a dual citizen. Now, the question I'm asking is, wasn't that an issue for the Honorable Supreme Court to resolve? Was it not before them? Jallow was before the Honorable Supreme Court as a dual citizen.
Thank you.
Are you telling me that the Supreme Court could not have gone into that matter? In my view, the Constitution deals with citizenship and naturalization, an issue that the Supreme Court has full right to interpret, to have said what they needed to have said. Now, the issue of whether Jallow will be denied a Liberian citizenship is an issue that is yet to be determined. Until then, as far as we're concerned, Jallow is an American citizen, but not a Liberian citizen.
Jensen.
But in the capacity of the ruling, Jallo, since you ask Jallo right now, he want to get a passport. You want to get 2 passports.
Yeah, Jensen.
Not like Jallo. All other Liberians who are naturalized, I have heard people in America even saying, I have right now to go and vote in Liberia.
But that is wrong.
Heard that?
That's
Very
a mis-
good. That's the doubt that has been created by this ruling in the minds of Liberians.
You'll be misleading a lot of them because the opinion of the court is very clear. I keep telling you, Jensen, under the rules of pleading, my man, no court will deal with an issue that is not raised before it. No court will do that. If the court does that, the court will be engaging in adversarial opinion, and our courts are prohibited, even American courts are prohibited from giving adversarial opinions. The court will only decide on matters that are before it. What was the matter before the Supreme Court? The matter that was raised before the Supreme Court, it was not about dual citizenship. It was not about whether the Supreme Court must determine whether it was lawful for Jallo to have dual citizenship. That was not the issue before the Supreme Court. If you look at the ruling, if you look at the ruling of the Supreme Court, by implication, the Supreme Court recognizes that Liberian law does not recognize dual citizenship. Why? In our opinion, page 6 and page 7 and 8, the Supreme Court said on the question of whether Section 22.1 is unconstitutional, the Supreme Court was clear. They said that section that defines acts that are in violation was never in conflict with the Constitution. It means, by implication, that the law on dual citizenship remains and it is not in conflict with the Constitution. What is in conflict with the Constitution is the procedure to revoke the citizenship when those acts have been carried out in violation of the alien and naturalization laws of Liberia. Now, you are talking about what the rationale of the case is. Supreme Court should have gone into that issue because the man is personally a dual citizenship. What the Supreme Court is saying is that Jallo rights as citizen of the Republic of Liberia remain with him until there is a hearing in a court of law, not even at the level of the executive branch.
Where I differ with you.
Gentlemen, can I ask this question? Since you said that, I want to ask this question. Does the Liberian Constitution allows dual citizenship? Chelsea, you want to respond to that?
I can. The Liberian Constitution does not permit anyone to be a dual citizen. The same constitutional provision I'm quoting here, Article 29, allows all Liberians. It says what? All persons who, on the coming into force of this constitution, were lawful citizens of Liberia and shall continue to be Liberian citizens. Shall continue to be Liberian citizens, not in the capacity of being a dual citizen. Under Article 27 and 28, it says, and author want to frame that every Liberian has a right to change his or her nationality. It says that. So dual citizenship is not, as per your question, is not allowed under Liberian laws. That's a clear court provisions provided under the Liberian Constitution.
So do we need the court again to have to interpret that law? Because the law is stated already. Do we need to, like, if I understood what the councillor was saying, that for this to be properly, applied to a person, maybe the person, if they have to go through a court proceeding and everything, because he quoted the adversarial opinion, but having heard that maybe the person has a citizenship of another country, do you need to go before the court of competence jurisdiction to interpret the law again?
No, this is what needs to happen, right? The Supreme Court has no power to take. It has no jurisdiction under the Constitution to take on the power of lawmaking.
Yeah.
Article 22 or the provisions within the naturalization laws of Liberia can only be changed by members of the legislature. The Supreme Court can only interpret what the law says. They have no right to amend, neither to change any provision of the Constitution, neither the laws of the Republic of Liberia. They can say what the law is. Now, what is unfolding right now, it is our opinion that members of the legislature will take interest in these matters to, in fact, begin to look at the naturalization laws of Liberia. The sections cited, Article 22.2 and 21.1. If there's anything to change that, is there anybody to change that those provisions must be the members of the national legislature. The Supreme Court can only interpret those laws, and their interpretation should in no way be a lawmaking proceeding, or should in no way interpret the law to mean that the law, they can change a law to create another law. So your question, to answer your question, is that the Supreme Court has solved the people of Liberia can either petition members of the legislature if they feel there's any conflict within the laws. There can be referendum to revisit the provision on nationality, or then the lawmakers upon themselves can decide to change any provision within the Constitution or the statute as it is. So when the Supreme Court interprets, we look at it and say, well, the Supreme Court has spoken. The ordinary person now is wondering. Now, this is where I come in, and that's what I want to tell Ato. Jallo went before the Honorable Supreme Court in his case. The fact that Jallo was challenging the government of Liberia for denying him a passport, when the facts, Jallo has not denied not being an American citizen. So Jallo, as a person, went before the Honorable Supreme Court as a dual citizen. Now, someone want to tell me, say it wasn't an issue before the Honorable Supreme Court, right? I don't want to say that this wasn't an issue before the Supreme Court, because the Supreme Court will raise an issue, will get to discuss issues in the petition that goes before it. That's what I don't want to say. But in the interpretation of opinions or decisions that will come from the Honorable Supreme Court, is not only what the plain language of the statute is. The Supreme Court can at times withhold a decision because why? They know a decision that will affect the greater portion of Liberians. The Supreme Court has to be mindful how they address that, not just the singular issue that goes before it. Justice Scalia, he says, look, when people call themselves members of the Honorable Supreme Court, they have a greater decision to make decision that comes from there should be a decision that will affect the greater number of people. So when you're resolving the issue, I agree with you that, look, Jallo wanted to know whether he has standing to go before the Supreme Court for the Supreme Court to decide. I have no argument with that. I've told you initially that Jallo, as a person, the fact that he was denied, he has a right to go before the Honorable Supreme Court. He has standing to go before the Honorable Supreme Court. But Jallo going before the Honorable Supreme Court, Jallo should have taught twice. I'm a citizen of America, and now I'm a citizen of Liberia. So I'm going before the Honorable Supreme Court as a citizen of Liberia and as a citizen of America. Is it that Jallo is denying that he's not a citizen of America? No, he hasn't denied that. Is it that the Honorable Supreme Court is not aware that Jallo is an American citizen? They have stated they themselves recognize that Jallo is a citizen of America. Okay. So the Honorable Supreme Court realized that Jallo was in the position of dual citizenship. Now you say, okay, you know what? The Supreme Court is not going to be fishing out there, right? But what we're saying now is somebody said we're misleading people. But the doubt created is that somebody feel they can go to Liberia and vote, even though they are citizens of the United States. Is that a way to go about it? In my opinion, no. No Liberian should take on two passports to go to Liberia and vote and come to America and vote. That in itself is criminal. And when you are caught in the process, there's a different situation there. If I was given a chance to discuss the immigration laws, what it is in America, and the risk you take as a result of such a decision, we will go into that.
We will come back at this time to talk about immigration law. All right.
I differ with your answer. I differ with your answer you gave. As a practicing lawyer before the courts in Liberia, if I were contacted by Jallo again to raise the issue to question whether he can be allowed as a citizen and he must be given passport with the evidence, I will not file that paper on his behalf.
Very good.
The lawyers who represented Jallo at the time is the present, one of them is the present Attorney General of the Republic of Liberia, Councillor Musa Dean.
Okay.
Councillor Musa Dean could have never gone before the Supreme Court on the theory of the recognition of dual citizenship. He would never have done it. Could have never done it. Councillor Musa Dean went on the theory that no matter what the violation, Tish should have been given due process rights. That's
No,
it.
that was not. If you are right from what you said.
talk a lot.
No, no,
Let me
no, no, but
let me
no. Let
let
me correct this. Let me correct this. If what you are saying is right, that Councillor Musa Dane did represent Jallo, then what you say may not be right. I differ, because Jallo's interest was that he wanted a passport, and the government of Liberia having denied Jallo. Jallo's petition to the Honorable Supreme Court was that his right must be restored. Right?
You're not understanding what I'm saying, Jensen. Read the
Okay.
opinion. The lawyer who represented Jallo was Councillor Musa Dean. At that time, you're not Justice Minister during Christiana time period.
Right.
He filed a petition. He went on the theory that the procedure to revoke Jallo's citizenship was in violation of the Constitution. That's all he went for. Councillor Dean, who have never gone before the Supreme Court to say that the right to dual citizenship is a right under Liberian law. Why? The Constitution of Liberia prohibits dual citizenship.
Right.
Because it prohibits dual citizenship, even the legislature cannot change that provision of the Constitution.
So true. I agree with you. Right. That's so
when
true.
you said the legislature can go amend it, no. So even this
No, I did not say legislature can amend the Constitution. I did not say that.
Or maybe you were talking fast, like intuitive perception undertaking. You were talking fast.
No, let's see.
I will follow you.
No. Let me be clear on that.
Correct yourself.
The Constitution of Liberia can be amended, right? Citizens can petition members of the legislature to amend the Constitution. Any group of lawmakers can request for the Constitution to be amended. But those amendments must go through fine. So that's what I meant, and I know you knew what I meant.
And during that referendum, you saw that the Liberian people did not allow the change of that particular provision of the Constitution.
So true.
Good. So no lawyer will file. Cancel. Wait now. No lawyer in their right mind who is practicing will file a petition for them to recognize the man passport when the evidence shows that he did. They will only tell you, say, go and have a hearing. That was what the Supreme Court did. Now, on the issue of the act, even the legislature, the only thing they can do with Article 22 that have been interpreted by the Constitution, by the Supreme Court, is to come out with a proceeding that whenever you are in violation of the law as defined in Section 22.1, there must be a hearing consistent with due process as condition precedent before a condition precedent to revocation of citizenship. That is what the legislature will only do. They will not touch on allowing someone to have dual citizenship, except we have an amendment to the Constitution of Liberia.
That's what I think we all saying the same on that note.
So listen, the Supreme Court accept. If the Supreme Court was just going to rule and say, look, in fact, the fact that you are not denied that you are not citizen, and the fact that indeed you come here, you said, I call it due process, what kind of remedy you want so much from us? You are already, in fact, liable. You cannot be a Liberian citizen in the government. If the Supreme Court would have done that, it means the Supreme Court was indeed violating the Constitution itself. Because the Supreme Court cannot determine who is a citizen, cannot say you are a citizen or this. It will interpret what the law says about citizenship. That's all the Supreme Court has to do.
I agree. So with that being said,
under this argument, Council, it is left with the prosecutorial prerogative of the government of Liberia to just proceed, which will be a political administrative decision of the executive branch, that whoever that you have evidence that indeed the person has American citizenship, you go and take them to court and revoke their citizenship. But the court was clear and said, look, the executive branch of government, the Ministry of Foreign Affairs, the consulate, or the ambassador, whosoever in other country representing Liberia, does not have the authority to conduct a trial or a proceeding that has to do with loss of citizenship. Supreme Court says citizenship is the pillar of all of the other rights that we as citizens enjoy. So before you scrape somebody of that right, you must have a hearing consistent with due process. Because the Supreme Court said that, it does not mean that the Supreme Court has legitimized dual citizenship. No, it is saying give the man a day in court and proceed through the proper channel consistent with Article 20A of the Constitution. That's all. There shouldn't be confusion about this. And I want to take this medium. I stand before you because I'm speaking, and this is an authoritative statement. I'm not guessing here. Johnson, all Liberians who are listening to me, do not take this opinion to say that it is a pass for dual citizenship. No.
I agree with you, and I join you. I join you on that, and that's the singular basis for which
I'm coming, Johnson. Your argument is pushing them to say yes.
No. What I want to provide clarity. No. I need to provide this clarity. No. I need to provide this clarity. And moderator, please permit me to do this.
Yeah, go ahead.
I have said that Jallo.
I said, you give me chance more.
Yeah, give me chance. I said,
let Jesse provide clarity, then we'll go back to council.
Fine. I said to you that Jallo has been left with the understanding that he's in the position of being of a dual citizen. The Supreme Court, in my opinion, and I maintain, the Constitution is very clear on that. All of the members of the Supreme Court are aware that the right of any citizen to become a citizen or naturalized person is a constitutional right. It's that alienable right that live with me until I die. It cannot be revoked. It cannot be changed. So for the Supreme Court to have seen this law and to see a Liberian who now goes before it with a provision of the interpretation, nobody needed to.
You already made your clarity.
No. I'm coming. I am not saying that Jallo has a right of being a dual citizen, as you are implying. I am not sitting here to tell anyone that Jallo is a dual citizen and that you have a right to dual citizenship. No, Liberia recognizes a singular person. You must be a Liberian or not a Liberian. That's what the Constitution of Liberia says.
Thank you, Jensen.
So Jallo, but for Jallo's situation, Jallo remains in a position of confusion. Jallo cannot say, okay, Jallo he applied for a Liberian passport and he has a U.S. passport. So Jallo's in his own position.
Okay, Jesse. Yeah. Councillor.
Let me come in quickly.
Yeah, a couple of last questions. Go ahead.
Every Liberian, like for me personally, personally for me, I support Liberians to have dual citizenship, but that is the law. The law is the law until we can change it.
Right.
The law is the law because it has some economic bearing. There are so many competent, accomplished Liberians out of Liberia that really want to invest and can have input in this country, but these are things that can also impede them. I agree with that, but that is the law. That is why there was a problem during the referendum. There was a need for more time and continuous and intensive education as to the consequences, the impact, the output, the results of having dual citizenship for Liberians, especially Liberians who left the country and became citizens in another country and they are accomplished, they want to come back. But the education was not enough, so the propaganda was against the proposition for that process. But because as it is, the law says, and which is the law, the Supreme Court will not change it until we go for a referendum. We have to go for a referendum, and in order to do that, there must be sufficient education.
Okay. Thank you so much. Our time is fast spent. I just want to give us, another 2 minutes each because we need to know some of the advantages and disadvantages of being a naturalized citizen. So, Council, you give me 2 advantages and 2 disadvantages. And then we got to take a couple of questions from our viewers and then we can close because our time is fast spent already.
You know what? Are you talking about a citizenship, advantages and disadvantages of Liberian citizens?
Of the naturalized citizen.
Oh, the naturalized citizen.
Yeah.
Well, the advantages of naturalized citizen, I don't know who the kind of questions you are talking about, whether it goes across the race, whether blacks and whites.
Well, let's maintain our relationship with Liberia.
Only Liberian. For me, the advantages are so many. Economically, 1, Liberians will be able to come back to Liberia and develop the country. There are many Liberians that are accomplished. There are certain things they would like to do, but they can't do them now in Liberia because of this barrier when it comes to dual citizenship. Other African nations are, in fact, using the dual citizenship, but the law is still on the book. Another thing is that there are people on that side who are competent to be leaders in this country that will be able to do a lot for our country if they are given the opportunity, and if they are allowed to be dual citizens and they can come back home and proceed, it will benefit this country. Because first of all, I tell you something. In Liberia, we have a serious brain drain problem. I used to just overlook it that maybe just going to school in Liberia it means you learn. No, in fact we know anything here. Until you travel, you go in the Western world, you get educated, you go to the school there, you see the similarity, the gap, some of the deficiencies, the gap that exists. So the world is running. For those of you who are there, sometimes you come, I know how some of you guys can feel so disappointed. Liberia is way back. Liberia is so backward. So we need our brothers who have these exposures. Because I was opportune sometimes I interacted with some of those guys. I saw Liberians, qualified Liberians, willing to come back. But because of all of these things, they want to come home. They love their home. They feel very disappointed when they see the Ghanaians going home, the Nigerians going home. Those guys allow dual citizenship in their homes because one, for developmental purposes. So those are the advantages I observe that indeed it will be very good for us. But another disadvantage is a person who has dual citizenship may commit a crime in Liberia, he runs away, he can't steal money, he runs away, and he on outside, you can never get him. I remember when I was chairman of Access Recovery, we have a lot of dossiers of individuals who serve in government and were in the United States. That we don't, American government to just easily extradite a Liberian citizen who you have records of evidence of commission of crime. You know, it's somehow very difficult. So those are impediments.
Okay.
But obviously, that it's a good thing to have our Liberian brothers to have dual citizenship. Not other foreigners, but Liberian citizens. Liberian citizens must be given the right to be citizens of Liberia. But our government or the institution that is established to maintain the status quo needs to do more civic education, because that referendum we're going to. And the reason many people did not understand the propositions in the referendum. So when we're advising the stakeholders at the time, say, look, suspend this thing, take a year, educate the people. And when you educate the people, they understand the proposition, the advantages and disadvantages of these things, they will vote informally. But sometimes the people realize, they say, no, the lawyer is just for a particular thing. Oh, the people want to take our country from us. Oh, the people, that's the perception, because we're on the ground. But me, I in the courtroom, I interact with the people. So those are the problems. But it's a good thing to have president, because we have so many Liberians over there that really want to contribute to their country.
Thank you, Councillor. Thank you, Anthony Jensen.
I will agree with Arthur when it comes to the advantages, right? But when it comes to the disadvantages, there are a lot of issues that we don't take into consideration. And I still maintain, I don't even know what is applicable. And I make reference to the data of the United States of America. The American laws, somebody will say it considers dual citizenship. People make these statements without even knowing what the law of America says. I studied U.S. immigration law here. I know what the U.S. immigration law does. Now, let me emphasize this to those who decided to take two passports. Do not make that mistake. Never you make the mistake to take two different passports and go to the port of entry. And I say in a very plain sense. Let's say, for example, if Jensen went to Liberia on U.S. passport and got Liberian passport and decided to come with it, at the port of entry, what the immigration law of America says, you are considered as an admission. You are admitted into America on the very first day of entering this country. So the port notes in your passport. But before then, the port do their own investigation. Suddenly, there are a lot of, by the time you go to that U.S. embassy and you apply for a visa, there's record on you throughout until you enter this country. So you could either be arrested if you are a Liberian citizen, let's say U.S. citizen, and you went to Liberia and you bought or you pay for a passport, Liberian passport, and you came with it. When you enter the port of entry, the immigration officer standing right there has the discretion to make a decision on you. So one of the disadvantages you will have is you could either be arrested there and then and be charged, or they could send you right back. The second thing I would say is that, let's say, for example, you are a student, right? An American student will have reduction or a considerable amount in his tuition as a result of being an American citizen, a natural American citizen. If you decide to take on a dual citizenship, let us assume that that works under the U.S. system. In my view, not, because even the oath that you take every day, those who get naturalized is clear. And so there should be no argument. I don't have time to go into that. We don't have time to go into U.S. immigration laws. But if you decided to take on dual citizenship, one disadvantage is you will be allowed to pay taxes while you work in Liberia. Who's prepared to do that? You have to file taxes in America every year as a result of being a citizen of this country or even a resident. If you're here as a U.S. citizen and you go and take on citizenship in Liberia and the record is there, you will be taxed 2 times. Any money you make in that country will be taxed by the U.S. government. Why would you want to do that? But if you decide to be a U.S. citizen, you have all rights under the people law that permits you to work, and there are many benefits. If you get sick here, you can go and seek medical attention right here, right? As a result of being a naturalized citizen.
Yeah.
But if you go back to Liberia, you get sick, even our own medical facilities over there, that does not make that is in no way agreeing with our people to keep our people in a kind of a situation where they cannot get good medical facilities. So, but the advantage is there, and that's the reason why people come people travel and become naturalized in those countries because of the enormous benefit that they get. Now, for the law, on understanding of the law, we know that Liberia doesn't allow dual citizenship. America doesn't allow dual citizenship. There are a few island countries that America allowed to have those countries' passport and America's passport, but not for all countries that people want us to believe. American law is very clear on those things. Now, when it comes to immigration laws are changing every day. I never had the time to even go and do further research on the law that was cited. But we all must be clear on here that the 2 countries, as far as the laws are concerned, doesn't permit us to have dual citizenship. If we do that, you do at your own risk.
Thank you, Attorney Chelsea. Councillor talk about section 22 in one of his
22.2.
22.2. The person just put it. The person wanted you to elaborate on that.
Section 22.2 is talking about automatic citizenship. All right. And when you take on another, like for example, Jensen is in America. Jensen decided to be an American citizen by naturalization. The immigration law of Liberia says, 22.2 says, I automatically lose my citizenship with Liberia as a result of that, my decision. But, and that's the contention of this whole case, the Supreme Court of Liberia says Section 22.2 is in violation of Article 20A of the Liberian Constitution that says anybody before his citizenship for Liberia is denied, he must be accorded a due process, a procedure where you go to court and prove his case, why or why not. That's what Section 22 is all about. So it's about revocation. Do the government of Liberia revoke Jensen's citizenship because he had taken American citizenship?
Okay. And then the person
says, all about.
Okay, thank you, Anthony Jesse. The person said, I'm wishing Johnson explain the Liberian law and both international law. I don't know. They're talking, maybe they want to they are trying to compare on the citizenship or naturalization, but they were not very specific, but that's what the person said.
So we limit it to what we're discussing. I think that's what
you should compare the Liberian law to international law as a concern on naturalization or maybe citizenship.
Although it's vague, but I know after you can say something on that, or I can pick it up.
Maybe the person is just making a statement that the explanation has to do with law involving the national. But if we assuming we're taking it in that context, from the comparative analysis, some countries allow citizenship, maybe because in the constitution, some countries don't allow. But one of the interesting things, I was so surprised when the Chief Justice in the Supreme Court bench actually made an analogy when they were using the stare decisis, the precedent, with the American law. We took the words word by word from the statute of the United States on immigration.
And that's true. That's true. I thought I'm not. I mean, I'm just to inject. There's no joke about it. The immigration laws of Liberia and that of the U.S. is similar. Are the immigration laws, and I know what I'm saying, very, very similar in provisions. The only difference is there are the homeland security. These people have administrative procedural, issues that they handle in everyday activities. But the laws of the U.S. immigration laws, most of them are very similar, except that the U.S. laws, immigration law, is more detailed than that of Liberia.
Oh, okay. I just recognize the president, Isaac Johnson. Okay, he's my little brother. He's in Pennsylvania, I think.
Oh, okay.
He's my little brother.
Okay, we got another comment here. The person said the discussions around dual citizenship have so much advantages given the parameters of keeping it within the scope persons of Liberian birth or heritage to begin with. So
I agree with that. For me, I agree with it.
The discussion around dual citizenship has so much advantages.
Dual citizenship for us, for me, I think, one of the problems we have at Jensen, you remember when we were doing African law at the law school, Louis Adogrem. One of the problems we have is that I don't think we have to copy directly what American law is, and then we put it or we domesticate it in our laws, because we have a different culture and tradition and value. In Liberia, in Africa, you see the Republic of Ghana. Ghana has a reason why their people will go out there. They don't raise this issue because it has economic bearing. Other African countries around here, like Senegal or the other countries, they allow it because it has economic bearing. But for us, I think one of the things I observed is that our forefathers were very racist at the time when we were promulgating most of these laws, Jensen. Because the world now is changing. If you say, like, for instance, I have a brother who goes to America, and then they say, like, for example, the man is a citizen. You think that guy does not believe that he still has to come home? But you tell me that we say, look, the man should not come home, or even if he comes home, he's not coming as a Liberian citizen if he becomes a citizen. It has serious disadvantages. There are certain development, there are certain life the guys will touch when he brings investment here, he stays here, he lives here, and then he has the opportunity to compete in the both political and economic spectrum of the country. It will give advantages to the country. But if you deny him participation both in body politics and the economy to some extent, then obviously Liberia will be denied of certain things. For me, that's my own perception about it.
I said this as per Mr. Harris's question, right? We must be clear here. The U.S. government, even if you have a referendum tomorrow and decided to allow Liberians the laws of Liberia to consider dual citizenship, that's going to be a problem. The laws of Liberia will not hold anyone who is a naturalized American here. We must be very clear on that. If the laws of Liberia consider dual citizenship, and Jensen, as a Liberian by birth, came in this country and naturalized himself, and Jensen committed any crime, the laws of America will stand to hold me accountable for whatever that's happening.
Yeah, under American laws. That's correct. Under American laws.
Right. So then we ask the question, what is the need for enacting law for dual citizenship in Liberia, or for amending the Constitution and go for a referendum for a dual citizenship? What benefit do we, assuming Jensen was an American, get as a result of that? Jensen is not permitted to go to Liberia and have election. And let me send a caveat also to those who think that way. I've had a lot of persons who say, oh, thank God I can go to Liberia and participate into election. When you go to Liberia as a naturalized Liberian and you participate into Liberian election, that is automatic revocation of your citizenship with America. Now, I will say, oh, you must go to court for it, right? Oh, but yes, the immigration people here will definitely take the necessary action when it need be. And sometimes people do these things.
Jensen, when you say that, I disagree a bit. Because unless the Supreme Court changed that opinion, the U.S. Supreme Court, in the last case that I just cited to you, said that even if the person went out and engaged in an essential act, there must first be a hearing. The burden of proof must be on the standard of the preponderance of the evidence. That was the Supreme Court of the United States opinion.
I'm telling you today, the issue of going to court is an issue, but on the U.S. immigration laws, in fact, there are 5 principal things that no one who is naturalized in this country should be allowed to do in other countries. If you do that, it's automatic revocation.
Okay, and let's continue with our comments. We have time is far gone.
Yeah,
Salas is saying here.
For 1 hour, right?
Yeah, Salas is saying here. Our Liberian citizenship is fundamental of all other rights each can ever enjoy, and so to deny any Liberian that right because they naturalized in any other country is a disservice with all due process. Well, which we are talking about already.
That's correct. He's correct. He's correct. The denial must be with due process. But the Constitution prohibits dual citizenship for now. Until Liberians can amend the Constitution, that law remains the law. But to just take that citizenship like the way the government of Liberia wanted to do to teach Jallo, actually it was in violation of due process. That's why the Supreme Court said, no, you don't do that. You go to a proceeding.
And to just make a short comment, Mr. Harris, the only thing you can do for yourself if you're a natural born Liberian, if you love Liberia so much, do not come in this country and naturalize as an American. You do yourself the service to do that. So you can remain. There are other provisions of the U.S. law. You can live by here. You can become a green card holder and live in this country as much as you can. But when you take on U.S. citizenship, and better, the laws of Liberia permits all Liberians to make that decision. It's an independent thing. It's that thing that lives with you until you die. That right, that decision you make is a personal decision that you make. The whole issue of due process is just about, there is no code that will sit and deny anyone the right of naturalization. No code.
Yeah.
All right. It's written in the Constitution of Liberia.
This person says the government must continue.
Johnson, that makes anything correct. You're making some statements and that sometimes who told you there is no code that can allow for somebody to be denied citizenship in Liberia? The Constitution says, no, don't say that. The Constitution says that no person should be denied citizenship. No person should be denied citizenship without law, without due process of law. That's why the Constitution, the Article 24, 28, you're talking about.
Arthur, I'm maintaining here my provision. You don't understand what I'm saying here, Arthur. There are 2 laws that control in this. Let's say there's a law that control in this place. When you decide to be an American per se, the American laws guide you, right?
You're talking about Liberian law?
No, Liberian law. Listen, the Liberian law gave me right to make a decision to either be an American or Liberian.
Okay.
If I make that decision to be an American, I'm protected by the American laws.
Correct.
All right? And because I'm protected by the American law, the Liberian law cannot force me out of my right of citizenship. Cannot come and say, Jensen, no, because you naturalize an American, you are not American because we are not giving you right. The Liberian government cannot say, we are not giving you that right. So you're still a Liberian.
Okay, Jensen.
That's a right that is on to me that I take.
You are not a Liberian.
Can we give our closing?
When you say that, you'll be misinterpreting the Supreme Court's opinion.
I'm not dealing with Supreme Court opinion. Let's be clear on this.
You're making a very serious statement, and that statement has some consequences to follow if no interjections are made. You're making a statement that when a person becomes an American citizen who is a Liberian, are you saying that the Liberian government does not have authority to deny that person being a Liberian citizen? Is that what you're saying?
I said, and let me repeat, so that the consequences that you may be contemplating of. When Jensen decides to be an American citizen,
correct,
and I go through all of the procedures and take oath to be a U.S. citizen, Jensen is controlled by the laws of the United States and not the laws of Liberia. I maintain that.
When you own American soil,
If I leave the American soil, American protect me wherever I go as a naturalized citizen of America. If I go to
Okay.
Liberia, there's anything that's come about, the embassy in Liberia will protect me because I'm under the jurisdiction of America.
Meaning, in that case, you are. Yeah, I agree with that. In that case, you are an American citizen now.
Right.
If Now, but the Liberian government, if the Liberian government have established that indeed you are a Liberian citizen and they see all the documents, they must conduct a hearing, not at the level of the Ministry of Foreign Affairs, but in a court of law. That look, they have evidence to believe that voluntarily you have denounced the citizenship of Liberia and you are now the citizen of the United States of America. So that proceeding must be carried out to revoke your citizenship. The law
So
says.
I ask you a question. I ask you a
Okay,
comment.
gentlemen,
I ask
excuse
Ato my
me,
last
excuse
question.
me.
I beg you. Let me ask Ato my last question, right?
Yeah.
Ato, my question to you is this. Jensen has naturalized as an American citizen. He got his certificate as an American. He got his passport as an American.
Correct.
You cited me to appear before a court of jurisdiction like the Embassy of Liberia.
Yes.
And I do not attend that hearing.
Mm-hmm.
Am I still a Liberian?
The embassy, the Supreme Court in this opinion have said the embassy has no authority to conduct a hearing. It must be a hearing consistent with due process in a court of competent jurisdiction where the jury will decide.
Okay.
That's what I'm trying to.
So I bring that before you. I bring that before you in a court of competent jurisdiction.
Listen now, the day you come to Liberia, the court can exert jurisdiction over you. That's what the Supreme Court is saying here. The Supreme Court is saying there shall be no more hearing at the embassy, by the consulate. There shall be no hearing at the foreign ministry when they find out that you are a Liberian citizen and you have denounced your citizenship and you are now a citizen of different country. The hearing should not be at the department, the executive department, which is the executive branch. It must be conducted under the point of the judiciary. Not even the legislature must hear it. That is what the Supreme Court said in this opinion. That was what the Supreme Court said. So, to argue that our courts do not have authority to revoke your citizenship when you have announced and denounced Liberian citizenship, that's not true. The law says, the Constitution, in fact, is clear that the court can deny you, any person, they can deny you your citizenship, but with due process and in keeping with law. That's why your own law you read.
Okay. That's our closing remarks, and thank you so much for coming. Time is fast spent. We gotta go. Yeah, we have to come back here again and talk more about the citizenship matter and some other issues pertaining to the law. I want you to know it was wonderful having you on this platform on 2A Radio TV. Councillor Johnson, thank you so much for accepting our invitation. And I want to say you are welcome again. We're going to be sending you another invitation to be part of, this discussion.
Provided I have time, we'll become very busy.
Yes, when you have the time, whenever you have.
It's not really easy for Jensen to get me on the show.
I know.
I almost got mad. I mean, we haven't closed yet, but again, I say thanks for coming. We appreciate, the ideas. And let's send a caveat here. This discussion was not a legal advice for any Liberian. All right, our discussion is purely academic, and we hope that those of you who follow 2A Radio will take that. You have any legal issues, please find a lawyer. All right, and get and exercise your rights under the law. We only giving our opinions on those decisions that came from the Supreme Court.
Exactly.
Yet still, the Supreme Court decision is final. All right, we all respect that decision. Thank you so much, and we appreciate it. Thank you, our patient.
Thank you.
Yeah.